Get started in a second. Get it up to 50 and we'll go. Well, good afternoon, everybody. My name is Matthew Arnold, and I'm your Long Island Board of Realtor president, and I am happy to bring you at home together again. Special discussion for our brokers with LIBOR legal counsel, and on the line I have LIBOR corporate counsel Doreen Spagnuolo and associate corporate counsel Patrick Fife. And I hope this message finds you all safe and healthy, and I appreciate your time with us today. And with that, I will hand it over to our counsel.
Hi, guys. Hope you guys are all doing well, and thanks for joining us today. Patrick and I would like to go over a few different topics with you. One of the things is that the ESD guidelines for real estate remain in effect. The real estate in New York remains on pause, and it's still subject to the April 9th ESD guidelines, which has stated that real estate services were deemed essential with severe restrictions. Now, real estate services shall be conducted remotely for all transactions, including title searches, appraisals, inspections, permitting, recordation, legal services, financial services, and other services necessary to complete a transfer for real property. Now, a real estate service may be conducted in person only if legally necessary and in accordance with safety protocols. No brokerage office is to be open to the public. That is the same ESD guideline that is still in effect. Now, there have been many differing opinions and interpretations of this ESD guidance, since specific real estate activities and questions aren't covered. There are also terms used that haven't been defined. For example, legally necessary hasn't been defined. As a result, differing opinions have developed, causing inconsistency and some confusion. NYSAR has provided the field with answers to some frequently asked questions based on conversations NYSAR had with various governmental agencies. However, the ESD has not set forth any written guidance confirming what they told NYSAR over the phone. Now, the guidance is not entirely clear. Therefore, this creates a gray area. Each agent, in consultation with their broker, and each broker, in consultation with their attorney, must decide whether to follow the strict wording of the guidance, which states that all real estate services must be conducted remotely, and only if legally necessary can a service be performed in person, or rely on what the ESD has verbally told NYSAR. Now let's get to some of those frequently asked questions. Now, can a licensee go to a vacant or unoccupied home or vacant land to view it or take photographs for a listing? NYSAR states that based on conversations with the ESD, the answer to this question is yes, as long as you have the informed consent of the seller. NYSAR advises that if the property isn't vacant or unoccupied upon arrival, the licensee should stop taking photographs or videos and leave the property. NYSAR also advises against the use of third-party photographer or videographer, as they have not been deemed essential. However, there's an exception to this if the photographer or videographer received a waiver from the ESD for real estate photography or videography as an essential business. Can a professional photographer and or videographer take photos and or videos of a property? If the photographer or videographer has received a waiver or approval for real estate photography as an essential business from the ESD and provides a copy of such approval, the activity is permitted. Such approvals are on a case-by-case basis and is currently NYSAR's understanding that photography and videography as a whole hasn't been deemed an essential business. Only those individuals receiving the letter from ESD. Another question, can I go to a property where nobody is present? Meaning if individuals reside there and everyone has left the property to view it and take photos for a listing. NYSAR states yes, with the knowledge and informed consent of the seller. In the event that an individual is still at the property upon arrival or arrives while the licensee is there, the licensee should cease taking photos or video and leave the property. Can I have in-person contact with a member of the public? No. ESD guidance still states that all real estate services must be conducted remotely for all transactions. Can a licensee travel to a property, unlock the door so a customer may enter the property for an unaccompanied showing? Well, what if the licensee unlocks the door and waits in the driveway or out in the road until the buyer leaves? No, this is not permissible. NYSAR does not recommend that a licensee travel to the property in order to permit access to a member of the public. Any licensee choosing to travel to the property for this purpose is doing so at their own risk. Can a licensee do an in-person showing? No. All showings must be conducted virtually. NYSAR states that if the home is occupied, the licensee can only do the virtual showing if the homeowner leaves the property, since there cannot be any person-to-person contact. Can a licensee list a property and post it as unaccompanied showings only? NYSAR recommends that licensees should not be involved in coordinating an unaccompanied showing. NYSAR states that if the seller demands the buyer be permitted to view the property, the licensee should not be involved in the process. NYSAR states that a licensee can give the buyer the seller's phone number if the seller instructs the licensee to do so. Now, can a licensee conduct a final walkthrough with the purchaser? No. Licensees are prohibited from going to a property with their customer or client. NYSAR recommends the buyers and sellers speak with their attorneys about scheduling a final walkthrough without the licensee being physically present. The licensee may communicate with their client or customer via phone or video conferencing during the final walkthrough. Can the purchaser be present during the inspection? No. NYSAR states that ESD advised that the inspector can perform the inspection, but may only communicate with the purchaser virtually. Does the governor's executive order requiring individuals to wear face coverings permit licensees to have in-person contact if they abide by the requirement of the executive order? No. The new EO does not lift the restrictions on in-person contact between licensees and members of the public. What can happen if a licensee violates the on-pause order? The state can issue penalties that may range from a fine of $2,000, being charged with a misdemeanor, possible license suspension or revocation, possible civil liability, may be subject to a lawsuit, possible NAR Code of Ethics complaint violations. Now, you all are familiar, I'm sure, at this point that NYSAR has created and distributed a NYSAR COVID-19 disclosure form. NYSAR has provided this COVID-19 disclosure form for the members to use if they so choose. The form is optional. You can choose it or not to use it. If you use the COVID-19 disclosure form, you still cannot perform in-person showings. In-person showings are prohibited. Using the disclosure form does not change that. The LIBOR Executive Committee decided not to have LIBOR co-brand the form or make it available on our documents on demand for the following reasons. The form is readily available from the NYSAR website. Each broker will have to decide whether or not to use the form. And if a brokerage decides to use the form, that brokerage can co-brand their name on the form. If you decide to use the COVID-19 disclosure form, NYSAR asks that you please follow these guidelines. Each agent must have the permission of their broker before using the form. Each broker can decide to use the form, use a form the broker prepared, or not use any form. If a broker decides to use the form should be presented to the seller or buyer in the same manner an agency disclosure form is presented. Licensees should have the seller or buyer sign the form, print their name next to their signature, and provide a signed copy to the seller or buyer and retain a signed copy for the broker's file. The form may be delivered in any manner currently permitted, paper or electronic transmission, for example. Now, what does the COVID-19 disclosure form do? The COVID-19 disclosure form notifies the seller and buyers of the risks associated with permitting an individual to enter the property or by entering another person's property. By signing the form, the seller or buyer acknowledges that by permitting access or by accessing the property, they assume the risk of potential exposure to COVID-19. NYSAR states that licensees should explain to the seller or buyer that the form outlines the risks of COVID-19 exposure, and by signing the form, they're acknowledging and assuming the risk. NYSAR also advises the following regarding the COVID-19 disclosure form. In the event the seller or buyer is exposed to COVID-19 as a result of permitting or gaining access to a property, the form acts as a disclosure outlining the risks and having the party acknowledge that they're assuming such risk through their actions. If a licensee and or broker were named in a lawsuit alleging exposure to COVID-19 by the seller, buyer, or member of their household, the form could be used to show the seller or buyer were aware of the risks and assume the risk of permitting access or gaining access to the property. Now, what if the buyer or seller refused to sign the COVID-19 disclosure form? If the seller or buyer refused to sign the COVID-19 disclosure form, you should follow the same procedure when a customer refuses to sign an agency disclosure form. If the seller or buyer refused to sign the form, the agent should set forth a written declaration of the facts of the refusal and shall maintain a copy for the broker's file. Now, under what circumstances would a licensee use the COVID disclosure form while New York City and Long Island are still on pause? Licensees can give the COVID-19 disclosure form to sellers to sign under the following situations. Seller permits a licensee to enter the property to take photos, videos, or to perform a virtual showing. But remember, the seller must vacate the property when the licensee goes to the property. Licensee arranges for an inspector or appraiser to enter the property with the seller's consent. NYSAR states that licensees can open a property for an inspector or appraiser as long as person-to-person contact is minimized by using alternate means and granting access. Under what circumstances would a licensee provide the COVID-19 disclosure form to the buyer to sign? When New York on pause has been lifted and licensees are again permitted to coordinate in-person showings to a buyer. Should a licensee have a potential buyer sign the COVID-19 disclosure form while our area is still on pause, licensees are not permitted to coordinate in-person showings with the buyer, and having a buyer sign the COVID-19 disclosure form does not change that. Okay, now I would like to introduce to you Patrick Fife. Thank you, everyone.
Thank you, Doreen. So I'm going to shift gears entirely now and talk about something that hopefully is a little more encouraging for everybody out there, and that is the New York Forward Plan that Governor Cuomo and the state of New York have put forward. And specifically, I'm going to talk in more detail about how to prepare your businesses for the reopen. During the last presentation that Doreen and I gave, we gave a very general sense of what you needed to expect. But now that the New York Forward program has since been launched, there's certainly more specifics, not entirely the picture of what you'll need to do, but we're able to give you some more specifics about how you can prepare for the reopen. So first, I want to talk about the timeline for reopening. Many of you probably know already that the governor has created 10 regions, and there are 4 phases to the reopen. Long Island and New York City are separate regions of those 10 regions, and real estate is in phase 2 of the reopen. Regions will get to phase 1 once they meet 7 metrics, and you've probably heard many regions have already met those 7 metrics. Currently, as of this morning, I saw Long Island is still at 5, and New York City is at 4, but there was talk yesterday by the governor that Long Island is getting closer. Once a region gets to phase 1, it has been reported there will still be some time before it can advance to phase 2. Reportedly, it's an approximately 2-week period, but there's nothing specifically defined as to that length of time. And the state is issuing guidelines on how businesses in each phase can then reopen. So the phase 1 guidelines are already out. Now, phase 1 guidelines are a good prediction for what to expect in phase 2, which includes real estate. The phase 1 guidelines can be found at www.forward.ny.gov. In terms of my presentation, if there's one thing I want you to do and remember to do, would be to visit that website. I think it gives a really good picture of what all of you can expect once you need to reopen. There are summary guidelines for the phase 1 businesses, and those provide both mandatory steps that businesses must follow in order to reopen, as well as best practices. The state has advised that no waivers will be granted from the mandatory requirements, so you will need to meet the mandatory requirements in order to reopen. So for instance, if you can't procure the necessary PPE or operate safely, then your business cannot legally reopen. The guidelines also provide that all businesses must create a reopening plan, and I'm going to get into that a little bit later. So right now, what you should be doing is planning for the reopen. You want to be ahead of the curve. The curve has been flattened. There's a new curve now. There's a reopening curve, and you want to be ahead of that. So use this time right now to establish a plan for reopen, consider what issues need to be addressed, and develop that mandated reopening safety plan. You want to work right now on acquiring necessary supplies, make sure you've made modifications to your workplace that are to be implemented, and work on creating new work schedules. The phase 1 guidelines for each industry are all very similar. So phase 1 included retail, manufacturing, construction. I've gone through those guidelines, and there are similar threads in all of them that I think we're very likely to see in phase 2 when it comes to real estate. So the first of those guidelines, and these are what are in the phase 1, but again, I think they're very good indicators of what all of you will expect in phase 2. But the first is mandatory physical distancing. So you're going to be required to ensure 6 feet of distance between personnel unless safety or core function of the work activity requires a shorter distance. In tightly confined spaces like elevators, narrow hallways, they should only be occupied by 1 person at a time unless all occupants are wearing face coverings. If occupied by more than 1 person, you have to keep occupancy under 50% of maximum capacity. Anytime personnel are less than 6 feet apart from one another or a customer without a physical barrier such as plexiglass, personnel must wear acceptable face coverings in the office. You are going to be required to post social distancing markers using tape or signs that denote 6 feet of space in commonly used areas such as lobbies or other large areas on site. And you must limit in-person gatherings as much as possible and use telephone or video conferencing whenever possible. Essential in-person gatherings such as meetings should be held in open, well-ventilated spaces, appropriate social distancing among participants. The second mandatory part of the guidelines that we're seeing in phase 1, and again, this should apply to phase 2, and that deals with protective equipment. Employers must provide employees with an acceptable face covering at no cost to the employee and have an adequate supply of coverings in case of replacement. So you are going to need to have face coverings in supply before you reopen your office. Acceptable face coverings include cloth, homemade sewn, quick cut, bandana, and surgical masks. Face coverings must be cleaned or replaced after use or when damaged or soiled. They can't be shared, and they should be properly stored or discarded. You also have to have a plan for limiting the sharing of objects and computers, discourage touching surfaces, or when in contact with shared objects, you need a plan to keep infected, wearing gloves, sanitize before contact. There are also mandatory requirements for cleaning and hygiene. You have to limit gatherings, adjust schedules. There's guidelines for, not yet, there are guidelines for showings or open houses. Mandatory communication. You're going to have to affirm you've reviewed and understand the state-issued industry guidelines and that you will implement them. You're going to need to post signage to remind personnel and customers to adhere to proper hygiene, social distancing rules, appropriate use of PPE. You're going to have to train all personnel on new protocols, communicate safety guidelines, and establish a communication plan for employees, visitors, and clients with a consistent means to provide updated information. This is an important one. You're going to be required to maintain a continuous log of every person, including workers and visitors who may have close contacts with other individuals at the work site or area. We've heard a lot about contact tracing. The state wants employers to be a participant in that. So in the event somebody does test positive, they're going to call upon employers to provide a log to say, well, who has that employee or visitor been in contact with at your place of business? Also, if a worker tests positive for COVID-19, employers are going to need to immediately notify state and local health departments and cooperate with contact tracing efforts. In fact, I'll get into it a little later, but the business reopening plan, the template that the state has put out requires you to identify who in your organization is going to be responsible for notifying the state in the event that someone at your office tests positive. You will also need to conspicuously post that completed safety plan at your work site. So I've got it in front of me here, printed it out. We're actually going through the process right now at LIBOR of putting together our reopening safety plan. So again, it's something that all of you should do, but you go to that forward.ny.gov website. There is a form, safety plan, reopening safety plan template. The first page of it is on this slide. I encourage all of you to go. It's a 6-page form. Start getting it together now so that when we're notified that you can reopen, that you're ready. Because this is going to be a mandatory requirement that businesses must follow in order to reopen. Another step that businesses will need to follow is mandatory screening. You're going to have a plan to notify employees who are sick that they need to stay home or return home if they become ill at work. Businesses are going to have to implement mandatory health screening assessments. That can be questionnaires or temperature checks before the employee begins work each day, and for essential visitors as well, asking them about symptoms, positive tests, or close contact with COVID-19 cases in the past 14 days. These assessment responses must be reviewed every day, and the review of those needs to be documented. Again, you're going to have someone in your organization that you designate to review these daily assessments or health screening assessments. One recommendation, there's no requirement that temperatures be taken at the office, but there needs to be some mechanism that people are reporting their health assessment every day. So one way to do it may be, and this is outlined a little on the New York Forward website, have something in place so that people can do that health assessment at home before they get to work, and then it's reported before they arrive. Employees with symptoms are going to need to be sent home for medical assessment and testing. If they test positive, employees may only return after completing a 14-day quarantine. Employees who have had close contact with a confirmed or suspected person with COVID-19 but have no symptoms may be able to work with additional precautions, including regular monitoring for symptoms and temperature, required face coverings at all times, and appropriate social distancing for others. If you do have somebody who's going to do on-site screening, they should be trained by the employer and familiar with the CDC, DOH, and OSHA protocols, and wear appropriate PPE, at a minimum wearing a face covering. You also have to have a plan for cleaning and disinfection and contact tracing in the event of positive cases. So in addition to all those required guidelines, the state for each industry has additional best practices that it recommends. And again, these are in the phase 1 business guidelines, but I think we largely expect most, if not all of these, to be part of the phase 2 businesses as well. And those include limiting in-person presence to only personnel necessary for the current tasks. So they recommend adjusting hours to spread employee and customer traffic over different periods of time. You may want to stagger the arrival and departure times so you don't have everybody coming in the entrance at the same time, 9 o'clock every morning, and leaving at 5. You may want to adjust those times. They recommend creating an A and B team so that you may have, if you can, people who are going to work remotely on certain days and others who will be in the office. So if you have 2 people that share functions, maybe you can have one in the office and one working remotely. They recommend modifying the use and or restricting the number of workspaces and employee seating areas to maintain 6 feet in distance. Reduce bi-directional foot traffic by posting signs with arrows in narrow aisles, hallways, or spaces. So if you have an office that has 2 means of ingress and egress, maybe you make one an enter and one an exit. They also recommend prohibiting non-essential visitors. Obviously, if you're going to need to maintain a log of all visitors and identify who they've met with, in some cases, it might be easier to prohibit non-essential visitors. It lessens the administrative burden on you and also lessens the chance of spreading the virus if somebody has it. They encourage employees to bring lunch from home, reserve adequate space for employees to observe social distancing while eating meals. And this one I mentioned earlier, they recommend performing those health screenings remotely. So you have employees call in by telephone or electronic survey before they come. In this case, it was to the retail location. That was what was in phase 1. But again, it's going to very, very likely apply in phase 2, these same guidelines. And there's good reasons to consider adopting these recommended guidelines. I mentioned earlier, they reduce the spread of COVID-19. It also reduces the likelihood of having to close your entire office in the event of a positive result. So think about it. If you have everybody reporting to the office every day and someone tests positive, you then have to shut down for 14 days and quarantine all your employees. If you have it broken up and stagger your staff, you reduce the likelihood of having to have a complete shut down again, where people all have to work remotely. And you also reduce the risk of any kind of adverse employment claim or unemployment claims. There's been talk that if you can't provide an adequate protected workspace, an employee may have grounds for saying that they don't or can't report to work, and may then make an unemployment claim. So there's good reasons to consider adopting even the recommended guidelines. So what will the phase 2 guidelines look like? As I said, we don't know for sure yet, but as far as those general in-office requirements, they will probably be very similar to the phase 1 requirements that I just went over. And the big question I know most of you probably have is, what are out-of-office activities going to look like? What are we going to be allowed to do once we're allowed to reopen? We don't know the answer to that yet. NYSAR on May 6th did send a letter to the governor that many of you may have seen, and they suggested, this is only suggested, this is not approved yet, but they suggested limiting showings to 1 licensee and 2 consumers, limiting a final walkthrough appointment to, again, 1 licensee and 2 consumers, requiring all licensees, office staff, and consumers to wear masks during in-person contact, and avoiding in-person activities such as driving in a car with a client and attending a closing. So that may be what we see. We don't know. A sign of good news, Pennsylvania yesterday adopted guidelines very similar to this. It allowed for a reopen of real estate statewide, and the guidelines that were adopted were very similar to this. So given there's been close coordination between states, in particular New York, New Jersey, Pennsylvania, Connecticut, maybe that's something that's on the horizon for New York. But at this point, as Doreen said in the beginning, we remain on pause, and those ESD guidelines from April 9th remain the law of the land. But as soon as there is updated final guidance on phase 2, or if ESD makes a change, we will advise you as soon as possible. So that's it for our formal presentation. And I guess, Matthew, if you want to come back on and start firing any questions at us that may be out there.
Great. Thank you, Patrick. Thank you, Doreen. I do have a couple of questions. I guess the first one is, can a licensee travel to a property to unlock a door for a consumer for an unaccompanied showing?
The answer to that is no. The licensee should not be involved in unaccompanied showings at all. The only thing that a licensee can do is if the seller directs the licensee to provide the buyer with the seller's phone number, the licensee could give the buyer the seller's phone number, but the licensee should not be doing anything to make the arrangements or coordinating the buyer and the seller to have that in-person showing.
Okay. And can they vice versa? Can the seller be given the buyer's number as opposed to the buyer getting the seller's phone number? Does it matter? And
I don't think it matters. Yeah, I mean, if the buyer requests the seller's phone number, it would be the same thing.
Okay, great, thank you. And then in section 14 of the ESD guidelines, it states the legally necessary. Can we define what's legally necessary?
That's one of the issues, or one of the problems with this is that there is no definition of legally necessary. So, the section 14 states that in-person activity would be permissible if legally necessary, but what is legally necessary? The ESD has not given a definition of it, has not given any examples of it. And in fact, NYSAR made a statement, and based on their conversations with the ESD, that NYSAR says they cannot even think of anything that would constitute legally necessary to allow a licensee to do or to conduct an in-person showing. And that's where much of the confusion, I think, or miscommunication may stem out in the field, where people may be interpreting what they believe legally necessary means. You may have attorneys out there also stating what they believe legally necessary means. But right now, there is no definition of it. I cannot give an example of it. And you, as the brokers, you would be in the best position to speak with your own attorneys in regard to what you feel comfortable with and what they recommend.
Well, I have, I'm an active broker. I'm selling, or trying to. I'm getting a listing that's a court-ordered divorce. Would that be something that would qualify as a legally?
I can't, why I can't answer that is because I don't know what the ESD would consider it. If I had some guidance, or if the ESD came out with some written examples, I would be able to inform you. Yes, the ESD would permit a certain thing or not permit a certain thing, but not by having not any definition or guidance from the ESD, I cannot make a recommendation because I don't know if an investigator from the ESD came and looked at it, what their interpretation would be. So all I can tell you at this point in time is to look at the wording of that ESD guidance, interpret it narrowly for you, because that would be the safest course of action. So I don't know what an ESD investigator may decide what constitutes legally necessary or not.
Right. And to add to that, I mean, as an attorney, you normally have the ability to look at how have courts looked at something, what interpretations of regulatory bodies given to language, if it's a statute, what was the legislative history, what led to the creation. None of that exists here. I mean, this was just a guidance by the ESD and with no explanation, no interpretation. So there's really, as Doreen said in the beginning, it is a gray area because there's nothing to rely upon. There's no examples, there's no history, there's no way to see how this has played out. And all we have are those words, legally necessary. That's it.
Okay. Just for everybody's point of information, this PowerPoint will be available to everybody, I guess, on our lirealtor.com page.
The hub.
On the hub. Okay, thank you. Well, I think it's lirealtor/COVID, but it'll be on lirealtor.com. You'll see the COVID hub. Click on that, and this will be available, especially for the brokers. Will we be? Okay, great. Thank you, Patrick, for putting that up. Another question. If seller makes the appointment with the buyer, can the agent wait outside the property in their car?
That was another question that came up, and even NYSAR recommends no, that it could be looked at that if the agent is there and waiting in the car, they somehow coordinated the showing, or they could potentially perhaps bump into the buyer, bump into the seller during that showing, and that would be looked at as person-to-person contact. So the agent should not be on the property at all.
Okay. And just another point of clarification, there are no in-person showings allowed yet, correct?
Correct.
Thank you. And do you know if NYSAR actually get an answer to opening a house for an unaccompanied showing from a conversation with the ESD or from their own interpretation?
From my understanding is that based on conversations that NYSAR had with an attorney at ESD and other governmental bodies, that's where they obtain the information that they put out on their Q&A.
Okay. And I think some people are jumping on late. I have another one. If property is unaccompanied, can the agent unlock for the buyer to view? And I think you've already stated that clearly
no.
as no is the answer.
Correct.
And then there's another one. If a home is vacant and the listing agent has a lockbox on the home, the seller is allowing showings. How do we go about this? And you've already stated that we give the seller the buyer's phone number to arrange it, and that the licensee may not have anything to do with arranging the showing, correct?
Correct.
Thank you. I have another one here. We had a question about phase two, but that was before you talked about it. Okay, I have another one. I have a seller that is ready to list their property once we can start showing the property. The problem is both sellers have recovered from COVID-19 and have been home from the hospital for close to a month. Are we required to disclose that the owners have recovered from COVID on the listing itself or each time the house is shown? Great question.
Yeah, that's a really good question. And I guess the question is whether or not that would be material information that would need to be disclosed to the potential buyer, right? Who's coming in. And it's been stated that, of course, medical information is personal and it should not be disclosed. However, there may be an exception here because of the risks of COVID. There have been exceptions there've been exceptions in the law if it could directly affect the person's well-being in a dramatic way, which COVID has been deemed, to affect people's health in a severe manner potentially. So because of that, it may very well be that it would need to be disclosed and it would be considered material.
Great, thank you, Doreen. I have a seller in England and not coming back. How do I handle that? Well, I guess for any out-of-town sellers, I know we can take the listing through DocuSign and do a Zoom call, but this would, I guess, whether the house is vacant or not, if they had tenants, I'm just going to expand on Roy's question that if they have an out-of-town seller and whether the house is occupied or not, you may have a tenant in a house. Is there any difference in, I know we can't have the in-person showings, but is there any difference with out-of-town sellers or houses that are tenant occupied?
Okay, I guess with out-of-town sellers and the house is vacant and there's no one in the house, once again, the dealings or taking the listing with the out-of-town person or seller is fine as long as it's done all remotely, electronically. And that's acceptable. Then if you want to do a showing and there's no one in the house, you could still do remote or virtual showings when, as long as you have the seller's consent to do so. If there is a tenant in the home, I would then imagine that the seller would have to do what they can to make sure the tenant is not anywhere on the property when the broker then goes to the property to conduct the virtual showing with the seller's consent.
Now, with that question also, Doreen, I have I have a listing. We're working on getting it together, and it's tenant occupied, and the tenant is refusing to leave. Should we have any showings, or I have agents? I know I'm going to have agents that would like to virtually show the house. How do we handle a tenant occupied house that the tenant doesn't want to leave? He has belongings in the house, and they don't even, want to be outside of the house. They're not even waiting in the backyard. Can we not have any virtual showings now because it says that the house must be unaccompanied, it must be empty? What do we do with a tenant situation that doesn't want to leave the house when the agent's requesting to go virtually show it?
You know what? I guess it's almost similar to a situation where the tenant is living in the house and refuses an agent to bring a potential buyer into the house, right? You've been confronted with those type of things just on a normal non-COVID situation. So I guess in a way it would be the same. The agent cannot go into the house and conduct a virtual showing until there is no people on that property. There can be no person-to-person contact.
What about, we have an elderly population on Long Island, and some of them have houses, and they're not able to speak with the buyer, whether they're out of town or nursing home or what have you. Can they arrange to, or do they need anything in writing to assign a family member or a friend, non-realtor affiliated, to arrange for the showings of that house?
Can you repeat that question?
Sure. You know, we have sellers that aren't in town and, you know, can't arrange for the, you know, we're told we have to give the buyer and the seller each other's number. Well, if the seller is incapacitated or in a nursing home or isn't able to make that call, can that seller assign somebody else non-realtor affiliated to handle the showings with the buyers?
Well, that would be, I guess, like any situation. If somebody's incapacitated at the time and there's a power of attorney and somebody else has the authority to, you know, to make the arrangements for the showings or for the selling of the house. I mean, I don't see anything different in that situation, as long as when the showing is conducted, there's, you know, there cannot be anyone in the house. Once again, there could be no in-person showings. If somebody else has the authority from the seller, such as a power of attorney, and that is the person that the agent is dealing with, and that person who has the authority to act or make decisions on behalf of the seller tells the licensee, you know, give my number to the buyer. I guess it would be the same as the seller doing it, because they have the authority to act on behalf of the seller if, for instance, they have a power of attorney. But once again, there could be no in-person showings coordinated by the licensee.
Okay. Do you recommend that, I'm just going to add to that question, do you recommend they get something if they don't have a power of attorney? You know, we have a lot of friends that, you know, when you have when listings, they're like, the neighbor's always watching the house. Do you recommend we get something in writing written from the seller
You know what,
to
that would
kind
be,
of CYA the broker?
you know what, that question would relate to whether we're in an on pause situation, a COVID situation or not, right? That question really transcends across the board. Before a licensee would take any direction from somebody else on behalf of the seller, yeah, of course the licensee wants to make sure that that person has the proper authorities to make the decisions on behalf of the seller, and of course, you know, will protect the licensee to have something in writing. See, even if they have a power of attorney, get the copy of the power of attorney, and to make sure that within that power, that person has the authority to make decisions on behalf of a real estate transaction. Sure. Yeah.
What about a property manager? Can they let somebody in, a buyer in?
If they're a licensee, then they should not be coordinating any in-house.
The property manager being licensee?
If the property manager is a real estate licensee, you know, they should not be coordinating.
And just out of respect for our brokers, I know some folks, again, jumped on last, but I have another one. If we could just clarify, vacant renovated property seller gives the buyer the lockbox code. Just to reconfirm, and she just jumped on late, I guess, but the only way we can show a house under the code is that we give the buyer and the seller each other's phone number, vacant or not vacant, even if there's a lockbox on there, and the seller and the buyer make arrangements to get in that house.
As it stands now with the ESD guidance, there can be no person-to-person contact. Therefore, a licensee should not be coordinating in-person showings. All real estate services, according to the ESD, must be conducted remotely. If a seller directs the licensee to give this the potential buyer the seller's phone number, the licensee may do so, but that is it.
Okay. Here's a great question. Can you do an in-person listing appointment if the seller is not capable of signing paperwork electronically?
Then you'll have to make other you have to make other arrangements. You can mail the paperwork, have them sign it, and mail, you know, and mail the paperwork back. You have to figure out other ways that you can get whatever paperwork you need to have signed done without it being person to person or in person. You can mail it. That, you know, that would be fine. Mail it to them and have them sign it and mail it back.
Thank you. I don't know if you can answer this one because I know it's not you that made it up, but what is the logic in a licensee not being allowed to coordinate a showing that will be unaccompanied?
The logic, I can't state why ESD made the, made the statements that they did, but that's even expounding upon it, because right now, going back to 14, the ESD guidance, there can be all real estate services, no matter what it is, must be conducted remotely. There should be no in-person or person-to-person contact unless it's legally necessary. But then that brings us back to the question, what's legally necessary? And that's where, unfortunately, that's where confusion and misguidance, misinterpretation comes from, because that's all we know, all we have right now in black and white in front of us is that all real estate must be conducted remotely, in person only if legally necessary. And there's no definition of legally necessary.
Thank you, Doreen, for clarifying.
We would love to have a clearer definition, and we didn't advocate for these guidelines, and we feel for everyone out there. I mean, it's not something that the message that we necessarily like to deliver, but it's the law of the land, and it hasn't changed at this point. Hopefully, it changes soon, but again, we're kind of stuck with what we were given, and we're just trying to give you the best guidance and the appropriate guidance on what you need to deal with.
Thanks, Patrick. And this is another good question too. I know mine does, but should offices have a written policy regarding COVID issues at this time?
I think the answer is yes. There should be something. I think it protects the office and makes sure everybody's on the same page, and that you don't have people going off, agents going off and doing their own thing. I think that goes with respect to current operations, but like I said, going forward, you're absolutely going to be required to have this reopening safety plan. So if you don't have one now, get working on one so that once it's clear you can reopen, you're legally able to reopen.
Thank you. Does the governor's executive order impact liability insurance and errors and omissions?
Could you repeat that, please, Matthew?
How does the governor's executive order impact liability insurance and errors and omissions?
I'm not really sure specifically what the intent of the question is. However, if the question, by that question you mean that if a licensee violates the executive order, would they be covered by their E&O insurance? If that's what is meant by that question, you're going to have to contact your insurance carrier to find out, what all of the exceptions are. But one exception that I'm aware of across the board for the most part, if there's an intentional violation of the law, most insurance companies, insurance won't cover if the licensee is then sued for a violation. But for more specifics about what your coverage covers and the exceptions and don't cover, you should contact your insurance carrier.
Okay, thank you. I had another manager of the property, house is empty. As manager of the property, can I open, assuming he's a realtor, so as long as anybody is licensee, manager, management, watching the house, absolutely no licensees can arrange any showings or open up the property. Is that correct?
Correct.
Okay, thank you. I just wanted to cover that off. And again, we will have this link. We had a question, will the webinar be available? They'd like to listen again. So the link will be in the lirealtor.com page, the COVID hub. Now in phase 1, I know no in-person showings, including a realtor, but can the seller actually show the buyer the home that is in person? Can seller show the buyer now if they organize it? So even though the buyer and the seller, just to kind of clarify, I think I know where she's going with this question. We put the buyer and the seller in touch with each other. You know, we have a lot of sellers that, you know, even when you're showing the house, you always tell them disappear, you know, don't be here when I'm doing the open. Don't be here when I'm doing the showings. What do you make recommendations to this as a licensee? Do you make a recommendation to the seller? Look, I'm going to put you in touch with the buyer. You two can arrange the showing. You know, and a lot of sellers, they have pride in their house and they won't leave. Are we, I guess the question could be also is that, are we liable after we put buyer and seller in touch with each other and the seller decides to go ahead and show the house and the buyer comes there and the seller's walking them through the house?
Okay.
But
A number of things with that. You know, you don't want, the licensee shouldn't be putting the seller and buyer in touch with each other and telling them what to do or what not to do. What NYSAR has recommended only that the licensee could do is if the seller asks the licensee to give the buyer the phone number, you do that and that's it. Now, you know, once again, we don't know, like I said before, we don't know what an investigator from ESD is going to look at. What they're going to determine is violating that section 14. So any decision as the broker that you make that brings you closer to what maybe could be conceived as coordinating these buyer and seller to meet and have an in-person showing, there's an inherent risk there. You're going to have to make the determination, you know, how close to that coordination are you willing to go? As LIBOR attorneys here, we take a look at the most restrictive meaning of what this ESD guidance states, and it says and we would say you don't do anything. Everything is remote. You don't get involved in anything. Based on conversations that NYSAR had with the ESD, NYSAR was comfortable putting out saying that the licensee could only give if the seller asked, the phone number to the buyer, and that's it. Anything closer, anything you do that moves closer, that could be interpreted as the licensee coordinating the seller and the buyer getting together, having an in-person showing, puts the licensee at risk.
thank you, Doreen. Here's another good question. You know, a lot of our realtors, we own houses. You know, a lot of them are developing. A lot of them are doing flips, you know. You know, you're a realtor, you're licensed, you know, it's like a doctor. You give medical advice. You're always a doctor, whether you're practicing or not. We have a license, and a lot of folks buy houses and they flip them. How do we best handle that? You know, this is a great question because, you know, I bought houses before, renovated them, put them back on the market. I'm a licensed realtor. I'm the seller. Buyer wants to see my property. I'm supposed to arrange it. Buyer and seller are supposed to arrange it. How do we tackle something like this?
Well, I guess your main question is to yourself, once again, what is the risk level you're willing to take? And you look at yourself, if I put myself in this situation, how much risk do I have as a licensee? As a licensee, I'm not supposed to coordinating in-person showings. I'm not supposed to be involved in in-person showings. So are you going to take off your licensee hat and act like the seller? But will that take you away from any liability as a licensee? That's a determination you're going to have to speak to your attorney about. But you're a licensee, so no matter what, there's a level of risk when you make certain decisions because you still hold and maintain that license. So a question like that, I would recommend that you speak to your personal attorney on what would be the best course of action.
I'm just going to add to his question is, because I think this is a valid question. You know, realtors, we believe, you know, real estate is the best driven investment in life. But, you know, do you think we could assign, you know, we're not going to give up power of attorney of our own real estate, but can we assign a non-realtor to handle the showings? Would that be something
You know
And
what?
I'm adding to this question.
I know,
I'm
Matt.
sorry if I'm,
Well, right now, licensees should only be involved in remote or virtual showings. So it could be
okay.
done a remote showing or a virtual showing. Whether or not to assign something, would that be looked at as you're coordinating an in-person showing? I can't answer that, but it might, will that bring you closer to a risk level of coordinating an in-person showing, bringing buyers and sellers together? I cannot answer that. I don't know. I don't know how ESD will view it. What I would say is you should speak to your attorney, what the risks may be in doing that, and make a decision accordingly.
Thank you, Doreen. I think I know the answer to this, but how are we protected that a buyer and a seller won't conduct business without us? I mean, I know we have a listing agreement, X amount of time, and hopefully everybody now is doing buyer listings, getting buyer contracts signed, but is there any recommendations? Valid question. We're putting buyers and sellers, and even when we don't put buyers and sellers, the buyer's always trying to get, there's always one, out of 1,000 that may try to get the seller's phone number and have some type of contact with them. But are there any other steps other than having our listing agreements done that we can protect us from getting outside deals without our knowledge?
I mean, I don't, I think you would have to answer that question based on what you would do on a normal basis. I don't think there's anything specific or different just because we're in, the COVID situation that we're in now.
Yeah, I mean, the same considerations would apply. I mean, you could have people in a non-COVID situation trying to coordinate something behind your back. And so whatever measures you would have in place to avoid that would be the same that you would apply in this situation.
Okay, I got a couple of questions and then we're going to start to wrap it up. If a tenant is not able to leave a rental, what obligation does agent have who rented the house as a cooperating agent? And then it's a two-part question. A tenant cannot find another place to rent. Is the renting agent responsible or liable in any way? So two-part question, sorry.
I mean, is that, is that specific to the COVID situation that we're in? Just rephrase that question, please.
A tenant cannot find another place to rent. Is the renting agent responsible or liable in any way? And then I'll ask the other part after you digest that one.
I mean,
Well, how about this?
I'm following you.
It's a little unclear, but
well,
I mean, evictions right now are on hold. I mean, I don't know if that certainly plays into it.
I think their concern might be that we did the rental, put it together, signed a lease. I had one where the tenant couldn't pay it and they left, and they're still obligated for the lease, but that's the tenant's issue. But maybe she's referring to, because her first part of the question was, if a tenant is not able to leave a rental, what obligation does agent have who rented the house as a cooperating agent? I'm thinking maybe Dee was saying, do we have any obligation to the landlord or to the tenant?
It's that the question seems to be very specific to this particular person who's asking the question. I don't know all the facts or all the details, so I'm really not in a position to provide an answer for that right now. Maybe that broker should speak to maybe their attorney, so the attorney gets the understanding of exactly what all the facts are in that situation.
Okay. And then I have some questions about the COVID disclosure. Right now, if an agent or broker cannot coordinate a showing at this present time, what's the use of the COVID disclosure? I guess maybe just clarify what the COVID disclosure is about.
Yeah, well, like I said earlier, the COVID, the disclosure can be used can be used, let's see if you get to that slide too.
Yeah, for the
It's
one
up,
for
yeah.
And while you're looking for that, that's the second part to that. Does the New York State Cova disclosure cover the realtor in most cases if signed by the buyer and seller if they make their own appointment? Does it still cover the agent?
There's a number of different questions in there. Okay, the disclosure form can be used now. You could have the seller sign the disclosure form now if the seller is permitting licensees into the house to do virtual showings, right? Also, if a licensee is going to permit an inspector or appraiser to go into the house, it would be a good idea if you decide to use the form. It's up to the broker completely whether or not they want to use the form or they want their agents to use the form. But if they decide to use the form and the licensee is making arrangements for an inspector or appraiser to go into the house, it would be a good idea to have the seller sign the form. Now, what does that do? The form is to protect the broker, right? It's so the broker, if the broker is sued because somebody said you went into the house to take a virtual tour, you allowed an inspector into the house to inspect the house. Because of that, now the seller or somebody in the seller's family contracted the COVID virus, right? And if the broker is sued based on that, the broker could say, listen, the seller signed this. And this disclosure form shows that the seller knew there was a risk and assumed the risk that by somebody going into the house, the licensee to conduct the virtual tour or the inspector to go into the house, that there was a potential risk. That is what the disclosure form is set up to do right now. As far as for a buyer, right now, the licensee should not be coordinating buyers to go into the house. So I don't see why the licensee would have a buyer sign it right now, unless there's a specific circumstance. But that COVID form is for the to protect the licensee. Now, I think another part of that question was, if the seller and the buyer themselves are making the arrangements to view the house, should that disclosure form be signed? But think, who is that disclosure form protecting? It's not protecting the seller, it's not protecting the buyer, protecting the agent, right? So if the agent is not coordinating that in-person showing between the seller and the buyer, why is the agent having them sign it? And then if you do, is that one step closer to being accused of coordinating the showing? I don't know. That's something you're going to have to decide on whether or not that's a risk. Does it take you one step closer? Is that proof that you somehow coordinated it? I mean, I can't answer that question right now. All I can say is the licensee should not be involved in coordinating this showing by the seller and the buyer together.
All right, a couple of quick questions and then I got to wrap it up. What if the agent refuses to give the seller or the buyer's phone number?
Say that again? If the agent?
What if the listing agent or the buyer's agent refuses to give either's information?
Then you conduct your remote showings. And what else can you do?
All right. And then let's just break it down real quick. All right. Either virtually we show the house, right? Our buyer says they want to buy it. They put in an offer. Seller accepts the offer. Now we're at the inspection stage. Okay. How do they handle the inspection?
NYSAR's Q&A based on conversations with the SD and other governmental bodies states that licensees are permitted to coordinate the inspection or appraisals.
Okay. So the licensee, do they go to the house, open up the door for the inspector? Or how do you recommend we handle that?
Well, what NYSAR has recommended based on the conversation, now based on their conversations, which I wasn't I didn't hear the conversations, based on the conversations that they had, was that a person-to-person contact must be minimized. So having seen that in NYSO's Q&A, I would recommend that you do and whatever you can as the licensee to demonstrate that you limited person-to-person contact as much as you could. So however you decide to do that, document how you limited person-to-person contact when the the inspector went into the home or went to the home.
Last question on walkthroughs. How do you say we handle that?
Walkthroughs. Now at that
Final walkthrough.
the final walkthrough, the attorney should be involved in it at that point. A licensee should not be going to the house, should not be involved with coordinating that. At that point in time, it will be the contracts will be in place. You'll have attorneys involved. The attorney should be handling it, however that happens. Licensees, however, should not be participating in the walkthrough. They can be on a Zoom or FaceTime or whatever, and can speak to the buyer when the buyer is walking through at that point in time, because once again, it should still be done virtually by the licensee.
All right, and the last question. Right now in phase one, still no soliciting on the phone, right?
Yes, that remains.
No cold calling?
No cold calling. And that remains in effect as the state of emergency remains in effect.
Great. All right, everybody. Patrick and Doreen, I really want to thank you for all your time. And I want to thank all of our members and brokers and DRs joining us today. I hope this was helpful. And once again, please stay safe, stay healthy, and support each other. Thank you very much, everybody, for attending. Have a great day.
Thank you.
Thank you.